Good afternoon, ladies and gentlemen. Very nice to see so many of you here. I'm honoured and delighted to welcome Markus Gehring, long-serving, very well established colleague here in the law faculty, talking about a subject which is his passion and, of course, absolutely central for our future and tied in with Brexit. What more can you want? Mark is going to talk for about half an hour, then take questions, and we'll be finished by about 1:55 to enable you to get on to your next destination. Markus, the floor is yours.
Thank you very much, Catherine. I think it's always important to declare your biases right from the beginning. I've been living and working in this country for nearly 20 years. I've never worried about my immigration status because I teach EU law, so I knew exactly what my rights are as an EU citizen. But the last 2.5 years have changed a lot. So forgive me if I'm a great Brexit skeptic. And if that comes out too much, just be reminded other opinions are available. We recorded 2.5 years ago, a couple of short videos to explain why in our area, EU law makes imminent sense. And I had the privilege to record the one on EU environmental law. I strongly believe that EU environmental law makes eminent sense for the simple reason that the environment doesn't stop at any border. And if you want to achieve any of your long-term environmental objectives, maybe apart from soil health, you will need the collaboration of other countries. Right? We saw that in the 1970s, even if the UK had no emissions whatsoever, the emissions would come from other countries. So we need a high level of international collaboration, and that started in the 1970s. There's also a recognition that when you compete in a single market, when you compete on a zero tariff basis, well, you don't really want to compete on lowering environmental standards. You want to compete on the best product, the most innovative products. You don't want lowering of environmental standards giving anyone a competitive advantage. And that particular insight drove large swathes of EU environmental legislation since the early 1970s. What is maybe less known is that the UK played a decisive role in this development of EU environmental law. Right? It started with waste regulations. The UK was one of the first countries where you could actually trade parts of the waste stream, while most other continental countries still had that firmly in the public hands and no trade whatsoever was allowed. The first real piece of environmental legislation was then the Birds Directive. And this Birds Directive entered EU environmental law. It was adopted on the coordination of legislation for the single market competence basis, but it was largely driven by Dutch and UK bird lovers. You might know that it is a passion in this country to watch birds, to care for birds. One of the biggest environmental NGOs is actually the Royal Society for the Protection of Birds. And it was that group of organizations that really pushed the Birds Directive, which to this day remains one of the strongest pieces of EU environmental legislation. We then had legislation that didn't sit so well with some of the practices. For example, the Impact Assessment Directive is another milestone in '85. It's largely imported from US law, but applies not just to public projects, also to private projects. And the UK had a real, almost constitutional problem with that, and implemented it very, very late, arguing that its planning laws were absolutely sufficient to protect the environment and take care of the impacts that could be negative. I wanted to mention two more examples where positive UK influence arose. One is the Integrated Pollution Prevention Control Directive. The UK was one of the first countries that realized, from a scientific point of view, that if you cut pollution in one area, that might increase pollution in another area. Many continental environmental regimes had sectoral norms, not looking how if you reduce water pollution, you might increase air pollution. So it was really the influence of the United Kingdom in Europe that brought us the Integrated Pollution and Prevention Control Directive, which dealt with all forms of pollution in an integrated fashion. And one of the signature laws, and I spent a lot of time on climate change. I should say that part of this talk is based on a paper that I co-authored with Freedom Kai, who's in the audience, almost a year and a half ago, on the road to Brexit and what Brexit might mean for EU environmental law, and for UK environmental law, and for EU environmental law implementation. The problem is most of that has unfortunately not aged well. We've seen the ups and downs of Brexit that many of you will be familiar with, and I will not stop to mention in just a second. But one of the key pieces of legislation is the climate change emission trading system, which is so successful in the EU. It's a centerpiece of the climate legislation, and it's largely inspired by UK and Danish law. We tend to forget that it was the UK and Denmark who were the first countries to really implement carbon emission trading. Right? They had a completely different system. Maybe that's why it's not so well known. But it was first tested in the UK and successfully implemented, which then gave the impetus to try something that of the scale of the emission trading system that we have today. So the United Kingdom has been a key influencer in EU environmental law. The UK has also helped draft and help translate some of the, what I would call the Grundnorm of EU environmental law, Article 191. It's interesting because the UK managed to get a bit of a way out of the treaty. In all other languages, except in English, it says, the polluter pays, full stop. In English, you will note that the principle is called the polluter should pay, but might not if there are other circumstances. So we can see the other innovation in the Lisbon Treaty was the mentioning available scientific and technological data, i.e. science-based decision-making, which we've known in the UK for a very long time, now has a constitutional basis in the EU treaties, and that's thanks to the UK influence. Just to, the mind-boggling amount of EU environmental law, close to 85% of all environmental laws in the member states is now determined by EU legislative acts. And I think the list alone shows you in what areas we have environmental legislation, right? And some of the environmental legislation can be quite costly. If you're told by the UK, by the EU, to clean up your drinking water. That requires huge amounts of investment. So it's not for free to have a healthy, clean environment. France will, I fear, lose its case because the judgment will be published, I think, tomorrow on nitrous oxides. The Commission has taken France to the Court of Justice, saying France is not doing enough about nitrous oxides. And so having the Commission also as an enforcement authority is really, really important for environmental law, because some environmental rule breaches are done by public authorities, and we sometimes tend to forget that, I think. So now let's move on. That's the beautiful picture, lots of UK influence, and then comes Brexit. Now, I wanted to clear up some Brexit environmental myths right from the start, and if we have time, I can come back to this. Of course, we all know by now, I hope, that Brexit doesn't mean Brexit. Brexit means one thing to me and something completely different to someone else. There's also a myth that Brexit will not lead or will lead necessarily to lower environmental standards. That is not necessarily the case. We need to see how the withdrawal agreement is implemented. That's why the WAB is so important. How the withdrawal bill might be changed, how the translated EU law might be changed by government ministers. Will they step in and just take out large swathes of EU environmental law in the implementation in the UK? All those questions remain largely open. The government says, don't put anything into the WAB because it's unnecessary. We have the most ambitious environmental bill with a new regulator that guards against lower standards.
Just explain what the WAB is.
The withdrawal agreement bill. So the piece of legislation that actually turns an international treaty into domestic law. That is not necessarily the case. There are still some really crucial open question how powerful the independent regulator will be on the environment. We know it's at arm's length, but those who study constitutional law know that might mean different things. And at the moment, it looks like the minister could overturn any decision by that regulator, which is, to say the least, quite worrisome for the environment. International environmental agreements themselves don't necessarily ensure high standards. They are very broad in their scope, and they don't set the level of detailed rules that we've gotten to know from the European Union. Regulatory alignment is the fashion of the day. I must admit, the previous withdrawal agreement or the Chequers agreement had this idea that the UK could go out as an independent nation, influence international standards that then would have to be accepted by the EU, and therefore we shouldn't worry about regulatory alignment because there will be strong voice for the UK. Anyone who's ever worked on an international standard knows that is a complete myth. You know, you sit in an international forum, there's the EU with its standards, there's the US with its standard, and the two battle it out, and everybody else just falls into line, right? So you lose all level of influence for your standards if you breach out of the system. My pet topic is climate change. There is no solution to climate change only in the United Kingdom, right? You need the collaboration of other countries. Otherwise, all the efforts that you put in here in the UK are absolutely in vain. So again, not to work with the European Union on climate change doesn't make any sense to me. And when I said, look, we already know what the US wants out of these trade negotiations, because the USTR, the US Trade Representative, so the executive ministry, a bit like DEXEU, the part of the executive in the US that is responsible for trade negotiations, has put it on their website what their negotiation objectives are, right? And these are binding, these are authoritative pronouncements. So to say, these are not irrelevant, a bit like the tweets by the president, is what government officials said to me, is completely wrong. We already know what the ultimate objective is, and if you stack the UK against the US and the UK wants access for financial services, well then all the other things that might also be on your priority list might go out of the window. That's why I think the connection with international trade is so important, and that's the real, the main point I wanted to make for this talk. Let's accept for a minute that Brexit might eventually happen, and that the UK and the EU might eventually agree to some form of trade negotiation. What are the options is the question, and how can environmental priorities be safeguarded in those negotiations? And there's a paper that we wrote for the European Climate Foundation, which lays out available language. So language in trade agreements that has already been agreed somewhere in the world that could maybe pave the way, and I'll reference the paper in just a second. I wanted to first say that there are some fundamentals on trade and environment which I've spent a long time on. They're not in a black and white relationship. It's not that trade is always bad for the environment. It's some trade is good, other trade is not so good, right? If you trade renewable energy solar panels, that's really good for the environment, regardless how far they have to travel. Ideally, trade and investment law will foster, not frustrate, the transition to a low-carbon economy, and current trade and investment law can hinder, can permit, but can also actively support environmental protection and climate measures. And these are not just theoretical problems. We've had trade and environment disputes in the World Trade Organization for a very long time, for over 20 years. And most recently, we've seen the first climate and trade disputes arise on the horizon. We don't have time to dissect them, just to say that how you draft your trade treaties really matters for these disputes. So what are potential models for UK-EU environment trade cooperation? Well, these were the original models, participation in the EEA, the Swiss model, the Chequers Agreement. Let me do one thing. Let me dissolve those, because they're essentially off the table. I added a new one on the weekend, because I thought deep down, maybe some of my colleagues who have argued for the last 2.5 years that the UK is far too pragmatic to actually do Brexit. So maybe no Brexit is another element on the table. I don't think any of these discussions are completely obsolete in the case of no Brexit, because trade agreements will be done by the European Union, will be negotiated at European Union level, and the European Union could also strengthen its climate cooperation, its cooperation on biodiversity with other countries. It's not like EU trade agreements are just the best thing ever. There is a real danger that we are undercutting existing European standards in the interest of pursuing lucrative trade deals. I don't think the no-deal scenario is in anybody's interest. Just to say, the UK has already announced that if there's a no-deal situation, large swathes of climate legislation, for example, environmental legislation, might no longer be available, especially when it comes to collaborating with other European countries, for example, in the emission trading system. So what is left is effectively a UK-EU trade agreement, and so what are the options there is the question. So what we know is in the withdrawal agreement. In the withdrawal agreement, the old version, Mrs. May's version, so the May withdrawal agreement, we had a backstop that covered the entire UK. There was a very strong non-regression clause, right? It said very clearly that you're not allowed to undercut the existing environmental standards. Ideally, we would have a ratcheting up clause, right? So the higher standard should always be followed. Some countries do that, like there are some noise that in the relationship between New Zealand and Australia, they would want a ratcheting up clause, but at the moment, the best thing the environmental community can hope for is a non-regression clause. We've achieved a high level of sophisticated environmental legislation, so let's not slip under that standard. There's also a commitment to international treaties, to other multilateral environmental agreements, and most importantly, a firm commitment to a carbon price, i.e. to participate in the ETS, or to put a tax on fossil fuel or carbon. Now, all we have left is a political declaration. The political declaration emphasizes regulatory autonomy, mentions the Paris Agreement, and says potentially we could be in a position to talk about a carbon price. It's the opposite of a firm commitment to high environmental standards. That's why quite a few MPs are pushing for the non-regression clause to be enshrined in UK law if it can't be in the international agreement. I should also say that the new withdrawal agreement, the Northern Ireland only backstop, sees the IPPC directive and the ETS directive applied only to the electricity sector, right? Which is kind of slightly strange, given that other manufacturing, it should also be covered by this system. It will apply most product standards, such as car emission standard, to Northern Ireland, and the application of customs rules to Northern Ireland with a waiver for products going to the rest of Ireland and a rebate if tariffs are different is the sort of slightly more complicated free movement of goods construction that this new waiver has. We haven't seen any of the details. Even I take comfort in the fact that even the Brexit minister, Barclay, didn't realize that products coming from Northern Ireland will have to fill out a customs declaration as is required by the EU customs code. So there's still some talk how to implement this. I wanted to then move us on to what the UK could integrate in their trade agreement with the UK, with the EU. There are really good examples of a high level of environmental protection, a high level of climate ambition integrated in the text of especially EU free trade agreements. Here, the most recent one, EU-Japan, doesn't just mention the Paris Agreement, also requires steps to implement the Paris Agreement, otherwise you're in breach of this clause. In contrast, the UK has already signed an agreement that is more than just a rollover. It changes the UK Korea FTA. By the way, it used to be on the Korean Foreign Ministry's website. It was taken off, probably on the insistence of the UK, who didn't want to know that there is already an agreement agreed with South Korea. But because they didn't have a lot of data, they didn't have a lot of negotiation cloud, they didn't even change the reference to the Kyoto Protocol, which the substantive obligation ceased to be effective after the Paris Agreement comes into full force next year. So, the UK is already negotiating trade agreements for the post-Brexit era. No one is paying attention. The environmental community doesn't know what is going on. And the UK government, on our behalf, is concluding agreements that are hopelessly out of date or not as ambitious as the UK would want them to be. If you're interested in this, look at the paper, Legal Options for Post-Brexit Climate Change and Energy Provisions in the Future UK-EU Trade Agreement. We have lots more examples and have detailed how this could be negotiated. We also make proposals for a climate chapter, an energy chapter, the inclusion of the UK in EU legislation, regulatory cooperation harmonization, dispute settlement clauses. Catherine wrote an excellent piece on how the dispute settlement should really work, and how at the domestic level we need much more transparency. We need impact assessment, right? At the moment, the government is doing these deals without any transparency, without any assessment of the economic impacts of the different trade agreements. That is going to be a violation post-Brexit of the commitments made to South Korea. So what is my conclusion? Environmental cooperation has already been limited in the withdrawal agreement and the political declaration negotiated by Mrs. May. The old withdrawal agreement recognized the need for close climate cooperation, particularly in the backstop, and included carbon price as an important element. However, it falls short of full participation in the ETS. So it wasn't ideal before we started the last 2 weeks. But given that the UK-wide backstop has been dropped and replaced by a Northern Ireland-only backstop, climate cooperation is merely aspirational. Meanwhile, the new and old political direction leaves the question of whether any environmental cooperation commitments have been made at all worryingly open. The UK does not want to be obligated to maintain the entire key of EU environmental law, but full participation in the ETS without implementing all EU environmental laws or maintaining the same level of environmental protection. Most importantly, creating an independent supervisory institution is maybe something that could be contemplated. Even better, both parties could choose to safeguard strong environmental legislation within the side agreement or chapter of the new UK-EU trade deal. Existing FTAs could provide plenty of inspiration. A combination of the most robust provisions to ensure full compliance with the Paris Agreement and the highest level of ambition has the potential to trailblaze deep climate cooperation in a future trade agreement and potentially for all Paris Agreement parties. So I'm ending on a very positive note. Thank you very much.